I think then I think everyone knows that this, I just got an indication, a message that this meeting is being recorded. I'm sure you did too. What I'm going to do now is, now that we've had the parties introduce themselves, I'm going to ask, and I'm reading from the instructions that we've received from the chief judge. And with scoring judges, please look to the two bottom buttons on the lower left-hand side of your screen and turn off your audio and your video. So in other words, we won't be able to hear you or see you during the trial, but we know that you will be there. And these should remain, you should keep these off until the trial ends. I will, of course, let you know when to turn them back on. And you should also have your video set to hide all non-video participants. This means that the only people on the screen that you would see would be the advocates and myself. Okay. Any questions about that? Okay. All right. Now that we've done that, let's turn now our attention to, are there any preliminary matters? I realize that there is a limit on the number of motions or preliminary matters to which you can present to the court, but from the plaintiff's perspective, are there any preliminary matters to which you would like to bring to the court's attention?
Yes, Your Honor, we just wanted to turn the court's attention to a portion of Judge Pasquarello's pretrial order. Is that all right?
Certainly.
Specifically, ruling 12, which states that Stevie Rieger, Gray Grimes, and Frankfurt Johnson are unavailable under Rule 804A, as well as ruling 13, which states that at all times relevant, Frankfurt Johnson and Sunny Mehta were acting on behalf of defendant.
Okay, great. Thank you.
Your Honor, apologies. Yes, we just wanted to ask that due to the online nature of today's trial, if at any point you can't see or hear us, feel free to just interrupt and let us know so that we can get everything worked out as quickly as possible.
Certainly. And that's a great sort of ubiquitous suggestion for everyone. If obviously you have any problems, and if our main advocates get kicked off, we will probably know that immediately, but don't worry. I've judged lots of online tournaments this year, so I know that we will certainly halt the proceedings. We can even backtrack a few steps if we need to, if any material part of the trial, if you've missed it. So, okay. So if seeing no further preliminary matters from the plaintiff, let's turn to the defense. Any preliminary matters from the defense?
None from the defense, Your Honor. We are ready to proceed.
Okay. The court will constructively invoke the rule of sequestration. So any witnesses who are not parties would be excused, but of course, we're going to let everybody stay and listen to the proceedings. Okay, my next mandate from the Chief Judge is, well, now that we're moving into opening statements, everyone, we encourage you to be in speaker view. That is the button that is on the upper right-hand side of your screen. Attorneys, please remember, and this goes for everybody, please remember to mute all your audio unless, of course, you are speaking. So with that, we will turn to opening statements, and plaintiff's counsel, Ms. Hutten, the well is yours.
Thank you, Your Honor. Everyone agrees. It was obvious. A glass of wine, a seltzer, 2 more seltzers, a beer, and a shot. That's what this defendant, Sunny's rooftop bar, served Jessica Marks, a 5-foot-tall, 100-pound, 19-year-old college student. Then they let her walk out of the bar, get behind the wheel, and drive across 3 lanes of traffic and off a cliff. A glass of wine, a seltzer, 2 more seltzers, a beer, and a shot. Members of the jury, those aren't usually murder weapons. But in this case, they killed. That's why we're suing Sunny's bar for wrongful death. Because the law says that if a bar continues serving alcohol to a minor when they are obviously intoxicated and they die as a result, the bar can be held liable for their death. Now, when we brought this claim, we took on a burden of proof. Today, we have to prove 2 things by a preponderance of the evidence, or that each is more likely true than not true. First, we have to prove that Sunny's bar kept serving Jessica Marks when she was obviously intoxicated. And second, that their decision to do so caused her death. Now, members of the jury, I want to be clear. Today, we don't have to prove that Sonny's bar knew Jessica was intoxicated, only that they should have. Because here the law applies what's called a reasonable person standard. And all that means is that today we have to show that Jessica was acting in a way that would lead a reasonable person to conclude she was obviously intoxicated. Today, we'll show you that everyone agrees it was obvious, except the owner. So let's talk about the people that were there. First, you'll get to hear from Morgan Levin, Jessica's best friend. It'll tell you all about the symptom that all throughout the night, Jessica was displaying signs of intoxication. She was slurring her speech, not making sense, speaking too loudly. Everyone agrees it was obvious. And members of the jury, well, I want to be upfront with you from the beginning. Morgan Levin was also drinking. And today, we expect that Ms. Rulli is going to ask you to disregard his testimony because of this. But when they paint him as intoxicated, well, remember who served him those drinks. But of course, we won't just ask you to rely on Mr. Levin's testimony. We're also going to provide you corroborating evidence. You'll get to hear about another customer at the bar that night, Stevie Rieger. And he'll confirm exactly what Mr. Levin tells you. Everyone agrees it was obvious. So next, you're going to get to see a video that Jessica posted that night. We're going to ask you to believe your own eyes. You'll get to see for yourself how obvious those symptoms really were. Everyone agrees it was obvious, except the owner. That's why at the end of today's trial, we'll ask that you find Sonny's rooftop bar liable. Thank you.
Thank you, counsel. Now for the defense.
Yes, Your Honor. She chose to drink, and then she chose to drive. It's March 24th. It's the very last day of spring break. Jessica Marks is visiting her best friend in Los Angeles. She's ready to go all out. She's ready to make this one last night to remember. Members of the jury, today you are going to hear that the drinking in today's case, it started hours before Jessica Marks ever stepped foot in Sonny's bar. Today you're going to hear that Jessica Marks had a plan. She planned on drinking before she went to the bar. Then she planned on driving to the bar, where she planned on drinking at the bar and planned on driving home drunk from the bar. Decisions she made hours before she ever stepped foot in Sonny's. Decisions she made sober. And members of the jury, there is no dispute in today's case that Jessica Marks' death was tragic. It was horrific. 19-year-olds aren't supposed to die. She was young. She was in college. She was just beginning to figure out her life, and choosing to blame a 19-year-old for drinking, well, we know it's going to be hard. So let's talk about what specifically the law requires us to do. The plaintiff has filed their case under the Dram Shop Act, essentially a law that says that Sonny's bar is responsible if they continue to serve an obviously intoxicated minor. Essentially, this law means that, as Ms. Hutten just told you, they need to prove by a preponderance of the evidence that the employees of Sonny's bar saw that Jessica Marks was drunk, not tipsy, not buzzed, drunk. And then they need to prove that they served her alcohol afterwards. Today, you're going to hear that the plaintiff won't be able to meet their burden because despite what Ms. Hutten just said, it wasn't obvious to everyone that Jessica Marks was drunk. In fact, you're going to hear today that Sonny Mehta didn't see any of those symptoms of obvious intoxication. Let's walk through what you're actually going to hear. Today, you're going to hear that Ms. Mehta didn't really interact with Jessica Marks that night. You'll hear that she only spent 30 seconds at Ms. Marks' bar at any given time, that she was the only server in the entire bar, that she was constantly busy serving 12 to 14 other customers throughout the night. Yes, you may hear that the bar was loud. It was dark. It wasn't out of the ordinary for customers to be louder than usual. Jessica Marks was not the exception. But the evidence won't show that she displayed any other symptoms of obvious intoxication. In fact, Today, the defense will also rely on Stevie Rigger, a non-biased third witness who was at that bar that night. And he's going to tell you that he didn't see these obvious signs of intoxications at all. It wasn't obvious to everyone. And that's because, as Miss Levin will tell the court today, Miss Marks was a regular drinker. You'll hear that every weekend, starting when Miss Marks was in high school, Marks went out to drink. You'll hear that in college, she grew more and more accustomed to drinking. In fact, you'll hear today that she told Jessica Marks at the end of March 24th that she had gotten used to driving drunk. Now today, the defense has filed our own claim through something called an affirmative defense. And as difficult as it will be, we're going to ask you to look closely at the decisions Ms. Marks made throughout the night and assess them by something called a standard of comparative fault. And all that means is that if you find that more likely than not, Jessica Marks' own actions contributed to her death, then Sonny's bar can't be held liable. And today you're going to hear that the deadliest decisions made in today's case were the sober decisions made by Jessica Marks. You're going to hear evidence that she came to LA planning on drinking, she came to LA planning on driving, and that she did it throughout the entire week. You're going to hear that she was planning on drinking and driving to the bar, and drinking and driving home. So at the end of today's trial, we will ask you to find her not liable. Thank you.
Thank you very much to both counsels for your opening statements. At this time, we will move to the plaintiff's case in chief. Plaintiff, all witnesses have been previously constructively sworn for both sides, so you may call your first witness.
Yes, Your Honor. At this time, plaintiff calls Morgan Levin to the stand.
Morgan Levin, if you would please take the stand, you are ready to testify.
May I proceed, Your Honor?
You may.
Thank you. Good morning. Could you go ahead and introduce yourself to the members of the jury?
Good morning, everybody. My name's Morgan Levin.
Sir, are you in school?
Yeah, right now I'm going to UCLA, majoring in biology. Go Bruins.
Oh, Mr. Levin, do you know why you're here today?
Yeah, I'm here because I witnessed the death of my best friend, Jessica Marks.
I'm so sorry for your loss, Mr. Levin. I want to start at the beginning. I want to talk about Jessica. When did you first meet her?
We actually met in middle school. We were both in band, and she was first trumpet and I was second trumpet. There was always a bit of a rivalry between us, but that rivalry quickly grew into a very close friendship.
Sir, did Jessica go to UCLA as well?
No, she stayed back in Pennsylvania where we went to high school. She went to Drexel.
Did she ever come out to visit you in California?
Yeah, we tried to visit as often as possible. I mean, we were best friends after all. So she'd come out and visit every once in a while.
Sir, I know this might be difficult, but I want to talk about one of those visits. I want to talk about the night that Jessica died. When did you first see her that day?
We met at her Airbnb around maybe 8 or so. And then that's where we met.
Did you ever leave that Airbnb?
Yeah, after meeting at the Airbnb, Jessica drove us over to Sonny's rooftop bar.
And Mr. Levin, just to be clear, did you and Jessica drink while you were at Sonny's bar?
Yeah, we had a number of drinks.
And do you know who was serving you that night?
Yeah, our server was the owner, Sonny Mehta.
Let's talk about what you ordered. Would you recognize a copy of your receipt from that night?
Yes, I would.
Your Honor, we'll be displaying Exhibit 17 constructively outside the view of the jury.
Okay.
Sir, do you recognize this document?
Yes, that looks like my receipt from the night of March 24th. That's my signature at the bottom.
Does it look to be fair and accurate?
Yes, yeah.
Your Honor, we offer Exhibit 17 into evidence.
Any objection from the defense?
No objection, Your Honor.
Okay, Exhibit 17 shall be received and you may publish it to the jury.
Thank you, Your Honor. Mr. Levin, do you remember which of the drinks on this receipt Jessica ordered?
Yeah, I remember she ordered the bottle of wine, the 3 White Claws, one of the beers, and one of the green tea shots.
After Ms. Mehta served Jessica a beer, some of that wine, those 3 White Claws, and a shot, did Jessica appear intoxicated?
Yeah, she was definitely looking drunk, stumbling around, not always making sense.
Well, I want to talk about exactly what symptoms Jessica may have been displaying. While you were with her, Mr. Levin, did you notice Jessica slurring her speech?
Yeah, she would stumble over her words every once in a while.
Was she making sense?
Usually not. She'd always go on about just saying weird things about LA.
Was she speaking loudly?
Yeah, definitely louder than usual.
Mr. Levin, did she appear obviously intoxicated?
All I know is that she definitely looked drunk.
Well, I want to talk about a video that Jessica posted that night. Your Honor, we'll be displaying Exhibit 10 constructively outside the view of the jury.
Okay,
Mr. Levin, do you recognize this video?
Yeah, it looks like a screenshot from a video I took of Jessica that night.
Does it look to be fair and accurate?
Yeah, as far as I can tell.
Your Honor, we offer Exhibit 10.
any objection from the defense?
No objection, Your Honor.
Defense, I assume that you're familiar with the entire content of this video.
Yes, Your Honor.
With that, the exhibit, does this have an exhibit number, counsel?
Yes, Your Honor, this is Exhibit 10.
10, thank you. Exhibit 10 shall be received and you may play it for the jury.
Yes, Your Honor. Mr. Marks, could we go ahead and press play?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Mr. Levin, in that video, did you notice Jessica slurring her words?
Yeah, specifically when she was like, Mom and Dad, that was slurred.
Was she making sense?
No, she was like, everyone in LA is a model or an actor. That's not true.
Was she speaking loudly, like you mentioned earlier?
Yeah, definitely louder than usual.
And do you remember around when that night this video was taken?
I know we posted it at around 11, so I probably took the video around 11 p.m.
Was Jessica acting that way all night?
Yeah, basically right as we got to the bar, the drinks from the Airbnb kicked in and she was acting that way the whole night.
Did Ms. Mehta serve you drinks after that video was taken?
Yeah, on our way out the door, she gave us some shots.
Sir, after she served you those shots, well, what happened?
Well, we got into the parking lot and Jessica got into her car. And I remember following her in the Uber, and all of a sudden her car starts swerving and it goes over the median and off the side of the road. And I tell the Uber to pull over, run over to the side of the road. and I scream her name as loud as I can. But she didn't answer.
Thank you, sir. No further questions, Your Honor.
Thank you, counsel. Cross by the defense.
Yes, Your Honor. Good morning, Mr. Levin.
Good morning.
Mr. Levin, I'm so sorry for your loss, and I understand this may be very difficult today. So if at any point you need a break, let me know.
I appreciate that.
Mr. Levin, after Jessica Marks's death, Jessica's mom threatened to sue you. Is that correct?
Yeah.
But she didn't, did she?
No, I think the case fell through or something. I'm not really sure what happened.
Instead, you prepared with Ethel Marks's lawyers the day before your deposition. Is that right?
Yeah, I'd never really been in trial proceedings before, so I wanted to get familiar with what it was like.
You prepared with them for 2 to 3 hours. Is that correct?
Yeah, that sounds about right.
I want to begin talking about Jessica on March 18th. She came to visit you for spring break, right?
Yeah, for spring break.
And she brought with her 2 fake IDs, correct?
Yeah, one for her and one for me. She said it was a very early 21st birthday present.
Mr. Levin, you 2 used these IDs to drink at 8 different places over the course of that week. Is that right?
8 sounds about right. We were kind of bar hopping around LA.
Now, Jessica Marks also rented a car, correct?
Yeah, a Chevy Impala.
And she drove you to and from 5 of these different places, right?
Yeah, 5 of them, but the other ones we were just kind of walking around in between the bars.
But at 5 of these places, Jessica had a drink and then drove afterward. Do I have that right?
Yeah, that sounds about right.
Objection, Your Honor, under Rule 404, improper character evidence may be heard.
Let me get a quick response first from the defense. Counsel, what's your response to the 404 objection?
Your Honor, we're using this under 404 subsection 2. This shows Jessica Marks's plan to drink and drive. It shows it's a decision that she made going into the, or it shows that she had a plan throughout the week to drink and drive, and a decision she had on March 24th as well.
May be heard on those grounds, Your Honor.
Response, certainly.
Your Honor, they're using this testimony to show that she drank and drove in the past to make it more likely that she was going to do so on the night in question. This line of questioning isn't going to establish her plan on the night in question, and therefore, Your Honor, it is improper character evidence under Rule 404.
Any final word from the defense?
Yes, Your Honor, we don't believe this is improper character evidence. It establishes that Jessica Marks came to LA with a plan to drink over the entire week, with a plan to drive over the entire week. This carries over into the night of March 24th.
And counsel for the defense, how does this either boost the credibility, or how is it relevant to your theory of the case, or how does it discredit the theory of the plaintiff? The fact that this was a plan.
It's relevant to today's case because it shows that Jessica Marks made the decision to drink and drive on March 24th before she went to Sunny's bar. It shows negligence on her half.
Okay, all right. It's a very good objection, plaintiff's counsel, Ms. Hutten, but I'm going to overrule it. I'll give defense a little latitude here. Overrule.
Yes, Your Honor.
Mr. Levin, I want to talk about March 24th. You went over to Jessica Marks's Airbnb before going to Sunny's. Is that correct?
Yeah, that was where we planned to meet up.
And Jessica brought out a bottle of wine there, right?
Yeah, I think she brought out 2, but yeah.
I'm showing you what has been pre-marked as Exhibit 5. Mr. Levin, you're familiar with this exhibit?
Yeah.
And in this exhibit, or Your Honor, we offer Exhibit 5 into evidence at this time.
If you
Without
could
objection, Your Honor.
You have no objection, counsel?
No objection, Your Honor.
Okay with that?
Permission to publish this exhibit to the jury.
Yeah, we'll admit Exhibit 5 and you may publish it.
Thank you, Your Honor. Now, Mr. Levin, in this exhibit, Jessica Marks said the start of a big night, right?
I think it says the start to a good night.
A good night, my apologies. And underneath it, she put hashtag go big or go home, right?
Yeah. Then she also tagged me.
You know that that phrase, go big or go home, that can indicate heavy drinking, right?
I mean, it can.
After posting this, Jessica drove both of you to a bar, right?
Yeah, that was our plan.
And that was after you both had some wine.
Yeah, I think we each had like one glass or something.
No, Mr. Levin, when you got to the bar, it was dark. Is that correct?
Yeah, it was around 9 p.m. So the sun had set.
There were string lights outside, right?
Yeah, that was the decor of the bar.
There was music, correct?
Yeah, pretty loud ones too.
That's right. It's fair to say that it was pretty loud in the bar, right?
Yeah, I mean, it wasn't super busy since it was a Sunday night, but you could say that.
That's a yes to my question. It was pretty loud in the bar, correct?
Sure.
Now, Mr. Levin, I want to talk about your drinking. You don't usually drink, do you?
I never really cared for that much drinking, but I have a beer every now and then.
You would agree with me that you drank more at Sunny's than you usually did in college, right?
Yeah, it was because I was with Jessica. I usually drink more when I'm with her.
But Jessica, that's right, had been drinking since high school, correct?
Yeah, both of us had been drinking since high school.
Jessica had a drink almost every weekend when you went to parties in high school, right?
Almost every weekend. Springfield High was a pretty big party school.
You knew that she drank more in college than she ever did in high school, right?
That's what she told me, but yeah.
And Jessica told you on March 24th that she just felt buzzed. She felt fine, right? Those were her words.
Yeah, I was checking up on her a lot because she definitely seemed pretty drunk, but she'd always say she was just buzzed.
I want to talk about the end of the night. You guys stayed at the bar until almost midnight, right?
Yeah, I think we closed our tab at like 11:41 or something.
And then you chose to Uber home, right?
Yeah, that was my decision.
You offered your Uber to Jessica, right?
Yeah, I wanted to give her the option. I mean, I was paying for it already.
But Jessica told you, I've gotten pretty good at driving after a big night, didn't she?
I think that was what she said. Yeah.
She gave herself a sobriety test in front of you, didn't she?
Yeah, and she was always funny like that. She put her finger on her nose and walked in a straight line.
You remember being surprised that she didn't look as drunk as you thought she would, right?
At least for the sobriety test, but yeah.
And then Jessica got in her car and she drove away, didn't she?
Yeah.
No further questions.
Thank you, counsel. Redirect examination by the plaintiff.
No, Your Honor, at this time, plaintiff rests our case in chief.
Okay, Mr. Morgan, thank you very much for your testimony, and you're excused. Okay, my understanding is there are no halftime motions. Is that correct?
That's our understanding as well, Your Honor.
Okay, great. With that, we will move on to the defense's case in chief. Defense counsel, would you like to call your first witness?
Yes, we'd like to call Miss Mehta to the stand.
Mehta, if you would please take the stand. You've previously constructively been sworn, so you are ready to testify. Counsel, you may proceed.
Good morning, Miss Mehta.
Good morning.
Miss Mehta, what do you do for a living?
Well, I used to own a bar in Malibu, Sunny's Rooftop Bar. It closed down a couple years ago, so now I'm just looking to start my next business.
I want to talk a little bit more about that bar. When did you first purchase it?
Back in 2017, I owned it for about 3 years.
When you purchased your bar, did you complete state mandated training?
Of course, as a bar that sold alcohol, it was required.
What did this training entail?
Well, part of that training was seeing how to identify signs of intoxication in customers.
What are some examples of intoxication in customers?
Well, it varies from person to person, but generally it's loss of balance, red, watery eyes, loud conduct, slurred speech, flushed face, things like that.
What do you normally do if you see someone who is displaying these symptoms?
If I see anyone displaying those signs, I stop serving them. I have to.
Did you see Jessica Marks displaying those signs on March 24th?
No, I never did.
Okay, I want to back up and talk about March 24th some more. Where were you that night?
I was at my bar.
Who else was working?
It was just me and one of my bartenders, Frankfurt.
Where is the actual bar located?
Well, there's an upstairs and a downstairs area. The actual bar itself is in that downstairs area.
Were there any customers downstairs?
Generally, I didn't see many customers downstairs. Just every once in a while, someone would come in and out.
Well, where were the rest of the customers?
I could see them upstairs on the rooftop. That was kind of our thing. So most customers spent their time up there.
About how many people were up there on the rooftop on March 24th?
Probably 12 to 14 at a time.
And were you the only person looking after them?
Yes, I was the only person taking orders and serving drinks. And my other bartender spent all his time downstairs.
I want to talk specifically about Miss Marks and Miss Levin. Do you know what time they arrived?
Yes, I saw them walk into my bar at about 9 p.m.
And do you know what time they left?
Same thing, I saw them leave about 11:45. 11:45.
During the course of the night, did you serve them alcohol?
Yes, I served both of them drinks.
Starting when?
Just very shortly after they arrived, maybe 9:10.
What did you serve them?
A few different drinks, some wine, some beers, shots and seltzers.
Did you speak to Miss Marks when you served her this alcohol?
Yes, we spoke to each other every time she ordered.
Did she appear intoxicated to you?
No, every time I spoke to her, she never showed signs of intoxication to me.
Did you continue to serve her throughout the entire night?
Yes, I did, whenever she ordered.
About how many times were you at her table?
Between serving drinks and taking orders, it must have been about 8 to 10 times.
How long were you at their table each time you served them?
Definitely no more than a minute, probably 30 seconds at a time.
And when you were serving them, who was ordering the drinks?
They both were. They both ordered their own drinks.
Now, after looking at all these drinks, by the end of the night, did Jessica Marks appear intoxicated?
No, not to me.
Turning court and counsel's attention to Exhibit 26. Miss Mehta, do you know Stevie Rieger?
The name sounds familiar. I think he's a customer. I get a lot of customers, but I try to know them as best I can.
I'm showing you page 2, lines 13 through 15. In this deposition, it says, "We're here to talk about an incident occurred on March 24th. Where were you at 9 p.m. that night?" His answer is Sonny's. This is from his deposition. I'm now showing you page 5, lines 4 through 6. Question, did you ever see Jessica stand up? Answer, probably. She was there for a couple hours, but I didn't see her fall or stumble. Miss Mehta, did you ever see Jessica fall or stumble?
No, not ever.
Okay, I'm now showing you page 7, lines 6 through 8. Were you concerned with Jessica getting behind the wheel? Answer, she was in better shape than her friend. Her friend could barely walk in a straight line. Is that consistent with how Jessica Marks' friend appeared to you?
Yeah, her friend, Morgan Levin.
Objection, Your Honor, under Rule 106, may I be heard?
You may.
Your Honor, we believe that counsel is giving the members of the jury an incomplete picture of this deposition and of Mr. Rieger's evaluation of that night. Your Honor, if they're going to admit this portion of the deposition, we'd like to ensure that the jury hears Mr. Rieger's descriptions of all the symptoms that were being displayed that night, and we move to admit another portion of that deposition.
So what's the exact basis of your objection?
Your Honor, Rule 106, the rule of completeness, states that counsel can't admit just a portion of a piece of evidence if it doesn't give a clear and accurate picture of that overarching message of that evidence.
Defense counsel, your response.
Your Honor, we believe the testimony exhibits a complete picture. I can read the rest of the answer for page 7, lines 6 through 10, if you'd like.
Your Honor, we'd actually specifically like to move to admit page 4, lines 20 through 21.
As the court, I'm hesitant to enter a whole page of prior deposition testimony due to any number of maladies. It's hearsay. It could have.
Yes, Your Honor. I apologize. I'm not sure if I made myself clear. We just like 2 lines on page 4, lines 20 and 21.
Sure. So
May I
what
be
I'm
heard,
going to
Your
do.
Honor?
We'd be happy to
Well,
read
I'm
the
gonna make my-
report.
I'm going to make my ruling. I'm certainly going to allow the plaintiff on cross-examination. You will be able to read in any portions of the deposition as you like, since that's sort of been the precedent set with the defense. But at this point, and I think that should overcome any concerns, at least you perceive, with 106 dynamics. So with that, I'm going to deny your request, but certainly allow you to read them in during cross if you'd like. And defense counsel, you may proceed.
Perfect.
Yes,
with
Your
that.
Honor.
Thank you, Your Honor.
Ms. Mehta, is this testimony consistent with how Morgan Levin appeared to you at the end of the night?
Yes, from what I saw, Morgan Levin seemed a little out of it.
What do you mean by out of it?
Well, for example, as she was about to leave my bar and he was writing his name on the check, it seemed like he was having a hard time doing that.
Did you say anything to Jessica about Morgan?
But yeah, at one point when I was at their table, I nodded towards Morgan Levin and said to Jessica, "This one's not driving home, right?"
Well, if you were concerned about Morgan's driving, why didn't you ever cut him off?
Well, he wasn't intoxicated. He didn't seem intoxicated to me.
Thank you. No further questions at this time.
Thank you, counsel. Cross-examination by the plaintiff.
Yes, Your Honor. And before we begin questioning the witness, we just like to display and read that portion of the deposition. Mr. Marks, if we could go ahead and get that up on the screen. It states, "What makes you say Jessica wasn't perfectly sober? She was really loud and wasn't making a lot of sense." And with that, Your Honor, is it all right if we proceed with cross-examination?
Your Honor,
You may.
may I be heard?
Yeah, is there an objection?
Yes, Your Honor. No, Your Honor. I withdraw my objection at this time.
Okay, thank you. Ms. Hutten, you may proceed with cross. Thank you.
Thank you, Your Honor. Ms. Mehta, I want to start off by talking about the 2 minors you served at your bar. In 2019, you'd recognize a copy of Mr. Levin's receipt, wouldn't you?
Yes, I believe I would.
Your Honor, will be displaying Exhibit 17. It's already in evidence.
You may.
Ms. Mehta, you'd agree that their table ordered 7 individual drinks, correct?
That's correct.
They also ordered a bottle of wine.
Yes, that decoy red blend.
You'd agree with me there's about 4 glasses in a bottle of wine, isn't there?
Depends on how much
Objection.
you pour, but that's about right.
So, ma'am, that's a yes, there's about 4 glasses.
Roughly, yes.
So you'd agree that in total, their table ordered about 11 drinks.
That's what the receipt shows, yes.
Let's be clear, you think Jessica Marks ordered about as many drinks as Mr. Levin.
That's correct. From what I saw, they ordered about the same amount.
That would be 5 or 6 drinks, wouldn't it?
Yes, I believe so.
Ma'am, you're aware that Jessica was only about 5 feet tall.
That's what it looked like to me.
You thought she weighed about 110 pounds,
That's correct.
but it's your contention today that this 5 foot tall, 110-pound girl didn't show a single sign of intoxication after being served 5 or 6 drinks?
She didn't. Yes.
Okay, well, I want to take a look at a video that Jessica posted that night. Your Honor, we'll be displaying Exhibit 10. It's also already in evidence.
Objection, Your Honor, relevance.
Well, at this point, since the jury's already seen it, I'll certainly give plaintiff's counsel an opportunity to question the witness on it.
Yes, Your Honor.
Yes, Your Honor.
Overrule.
Ma'am, you've seen this video before?
Yes, I saw it in trial today.
You also saw it before your deposition, isn't that right?
That's right.
You'd agree that after watching this video, you said it looked like Jessica could be drunk. Isn't that true?
It's hard to tell, but yes, it's a possibility.
You didn't say she could have been buzzed.
And I don't believe I said that.
I didn't say she could have been tipsy.
I don't believe so, no.
Ms. Mehta, you said it sounded like she could be drunk.
She could be, yes.
Right. And earlier in today's trial, you heard Mr. Levin say that this video was taken around 11.
That's what I heard him say, yeah.
Let's be clear, you didn't cut Jessica off after 11, did you?
No, I didn't.
But she did tell you that she was driving home that night.
That's correct.
You didn't try to stop her, did you?
No, I didn't see any reason to.
Objection, Your Honor, relevance.
I'll allow it. Overrule.
Yes, Your Honor. Ma'am, that's a yes. You didn't try to stop her from driving home.
That's a yes.
You didn't take her keys or call her an Uber.
No, I didn't.
Instead, you served her a shot.
That's correct. That was their last round of drinks.
Ma'am, you served her a shot and then you let her walk out the door?
Yes, because she didn't seem intoxicated to me.
Ma'am, I know you're saying that she didn't seem intoxicated to you. You know that just minutes after she left your bar, Jessica Marks died, didn't she?
Yes, I'm aware of that.
She died just minutes after you served her that last round of drinks.
That's correct.
Thank you, ma'am. Nothing further, Your Honor.
Thank you, counsel. Redirect examination by the defense.
Yes, Your Honor. Ms. Mehta, were you there when Exhibit 10 was taken?
No, I wasn't.
Were you there watching Jessica's table, watching how she interacted all night long?
Not all night long. I had other customers to serve. I tried to watch her as best I could when I saw her, but I couldn't sit there and watch her for 3 hours straight.
Did she look obviously intoxicated when you were interacting with her on March 24th?
No, she never did.
How did she look to you?
She looked fine to me, sober.
Thank you. No further questions at this time.
All right, thank you. The witness may step down. You're released. Does the defense have any other witnesses who would like to call at this time?
No, Your Honor. At this time, the defense rests its case.
Okay, that's what I thought. All right, since rebuttal witnesses are forbidden in this forum, we can move directly to closing arguments. Ms. Hutten, and for both counsel, are you ready to move straight into closings?
Yes, Your Honor. Plaintiff is ready to proceed.
Yes, Your Honor. Defense is ready to proceed.
All right, great. Let's move right into closings. Counsel, the well is yours.
Thank you, Your Honor. There's been a phrase that we have heard over and over and over today. Obviously intoxicated. Members of the jury, that's just a fancy way of saying, was it clear that she was drunk? And so I want you to think back to what you saw in that video. Then I want you to think about someone close to you. It could be a son, a daughter, a husband, a wife, a friend. And I want you to ask yourself if you'd be comfortable with them getting in a car with Jessica behind the wheel. Would you be comfortable with that? Members of the jury, of course you wouldn't. So when the defense tries to tell you that, oh, she seemed okay to drive, well, you can say no. I saw the video. It was obvious to me that she was drunk. And if it is obvious enough that you wouldn't feel comfortable in that car, it is obvious enough the defendant should have cut her off. That is obvious intoxication. And that is exactly why the defendant is liable. Everyone agrees it was obvious, except the owner. But members of the jury, today, we couldn't just say that to you, we had to prove it. Because when we brought a claim of wrongful death, we took on a burden. We had to prove two things by a preponderance of the evidence, simply meaning more likely than not. That Sonny's bar kept serving Jessica when she was obviously intoxicated, and that their decision to do so caused her death. And like I told you at the beginning of today's trial, we didn't have to prove that the defendant knew Jessica was drunk. Didn't have to prove that they saw any of the signs. We just had to show that a reasonable person would know she was intoxicated. And today we showed you that everyone agrees it was obvious. So let's walk through what the reasonable people told you. First, you heard from Morgan Levin. He told you all about the symptoms that Jessica was displaying. Slurring her speech, not making sense, speaking too loudly. And today, well, Ms. Rulli tried to tell you not to listen to Mr. Levin's testimony because he was too intoxicated, because he didn't usually drink that much alcohol. Let's think about that. I mean, their response to us saying they overserved an obviously intoxicated minor is to say, we didn't serve that obviously intoxicated minor. We served this one. Members of the jury, that's absurd. They can't in one breath say that they would never serve someone who seemed drunk, then in the next try to knock down Mr. Levin's testimony because he was too drunk to remember anything. They kept on serving him. But fine. Well, let's do what the defense wants and forget about Morgan Levin for a second. Even then, we still brought you corroborating evidence. Stevie Rieger confirmed exactly what Mr. Levin told you. Told you Jessica was displaying the exact same symptoms, told you she seemed drunk. Everyone agrees it was obvious. So next, let's talk about that video. Because today, I don't just want you to take my word for it, or Mr. Levin's, or Mr. Rieger's. You can believe your own eyes. You saw the symptoms yourself. And a few moments ago, well, Ms. Mehta had the audacity to get up on the stand and tell you that she didn't notice any of this. That Jessica seemed perfectly sober. That's not how alcohol works. You don't act this drunk one moment, then flip a switch and sober up the next. Members of the jury, that's not reasonable. The defendant interacted with Jessica 10 times throughout the night, and that's not someone who passes as sober. The symptoms were there. Everyone agrees it was obvious. But today, well, the defense tried to reduce our case to a he said, she said. Tried to tell you that it was Mr. Levin's word versus Ms. Mehta's, but members of the jury, you know that's not true. Because today we presented you with fact after fact after fact that proves Jessica was obviously intoxicated. Mr. Levin said she was acting drunk. The video shows she was exhibiting these symptoms. Stevie Rieger said she was acting drunk. The only person who disputes that is the person on trial today. This is not a he said, she said. It's everyone against the defendant. Members of the jury, it was so clear that she was intoxicated. Any reasonable person can see that. Everyone agrees it was obvious. Members of the jury today, well, they tried to hide their actions by blaming the victim. Tried to tell you that it was a 19-year-old girl's fault, even though they served her 6 drinks. So members of the jury, when they say she chose to drink, so she chose to drive, remember that Sunny Mehta knew she was drinking. Sunny Mehta knew she was planning to drive. She is more responsible. Members of the jury, that's the sole purpose that laws like this exist, is she was the responsible adult. She was the sober adult in this situation. She should have kept Jessica Marks safe. Everyone agrees it was obvious, except the owner. Find them liable. Thank you.
Thank you, counsel. Defense counsel.
Yes, Your Honor.
Thank you.
She chose to drink, and then she chose to drive. Jessica Marks wanted to make her last night in Los Angeles unforgettable. She started the night off drinking, hours before she ever stepped foot in a bar. Then she chose to drive under the influence to a bar, a decision she made, knowing she was going to drink at that bar, knowing she had to get her car home from that bar. Miss Marks decided hours before she ever stepped foot in Sunny's bar that she was going to drink and she was going to drive. And that's an intentional decision that doesn't rest with Sunny's. Members of the jury, today's case is horrific. 19-year-olds aren't supposed to die. But today you heard that the cause of Jessica Marks' death, it doesn't lie with Sunny's. Look, we know nobody wants to blame a 19-year-old for drinking. We agree that bars have the responsibility to see when somebody's obviously intoxicated and to not overserve. But they don't have the responsibility to look after or supervise their customers. They don't have the responsibility to stop them from driving or take away their keys. Today, the plaintiff failed to meet their burden because they failed to show by a preponderance of evidence that the defendant, Sunny Mehta or Frankfurt Johnson, had any credible reason to believe that Miss Marks had too much to drink. They failed to show that these specific people saw any obvious signs of intoxication at all. And I want to make a big point about that because today you are given jury instruction. And in there, they say that in deciding whether or not Jessica Marks was obviously intoxicated, you may consider whether or not she was displaying symptoms to the defendant. Miss Hutten made a big point today saying that any reasonable person could look at Jessica Marks, see if she was showing symptoms. It didn't matter what Sunny Mehta saw, but what Sunny Mehta saw is important in today's case. Members of the jury, today the plaintiff talked a lot about Sunny Mehta's obligation to watch Jessica Marks throughout the night, to monitor her behavior, to ensure she wasn't drunk. Miss Mehta's job as a bartender is limited. Her only obligation is that if she sees someone who's intoxicated, she can't continue to serve. While today's case is confusing, we have to look at what the evidence really shows. On one hand, you heard Morgan Levin tell the court today that Miss Marks appeared obviously intoxicated, and on the other, you have Sunny Mehta saying that Miss Marks didn't show these symptoms. I want you to recall what you heard on Miss Mehta's direct examination, that we have the testimony of a third witness, Stevie Rieger, who was at the bar all night long. We have the objective testimony of a witness not involved in today's case. And what he says aligns with Miss Mehta's testimony. Miss Marks was fine. She was walking fine. At worst, she was loud in a loud bar. You heard she never stumbled. She never fell. But what you did hear was that Morgan Levin couldn't really walk at the end of the night. You heard that she had trouble signing her bill. Your Honor, or members of the jury, today the plaintiff has rested their entire case on the testimony of someone who was drunk that night. Someone who spent hours crafting her testimony with Marks's lawyers, someone who is grieving and hurting and looking for someone to blame now. Now, Ms. Levin said something else important in today's case, that Jessica was a regular drinker. You heard that almost every single weekend since they were in high schools, Marks went out drinking. You heard that her drinking only got worse in college. You heard that she was accustomed to drinking. Miss Marks had a tolerance. The evidence shows that at Sonny's bar, she didn't drink much more than she was accustomed to. But today, if you find that the evidence shows that Sonny's bar didn't show that Jessica Marks was drunk, then that's it, case closed. But as I mentioned before in opening statements, for negligence cases like the one we have today, the defense has the option of bringing an affirmative defense for comparative fault. This means you have the option of finding that Jessica Marks' her actions, her inactions, her decisions, they were a factor in her death. Let's look at the decisions Miss Marks made. Now, you heard today that Jessica came to LA with a fake ID. You heard that she was fully intending it to use at bar after bar, and you heard that she was successful. You heard that over the course of 7 days, Jessica was able to successfully get into 8 different bars. You heard today that she chose to drive to 5 of them. Then she chose to drink, and then she chose to drive back. Over the course of the week, Jessica Marks made the negligent decision to drink and drive again and again and again, and March 24th was no different. You heard today that Jessica Marks had wine before leaving to Sonny's. And if we look at an Exhibit 5, in her own words, she was intending to go all out. She was intending to drink heavy. She made the decision that night under the influence to drive to the bar, and she made the decision to drive home drunk. This was hours before she ever stepped into Sonny's. Members of the jury, the evidence shows that if Sonny's bar hadn't served her, she knew multiple other bars she could go to, where she could get alcohol, where she could make the decision to drink, and where she had already made the decision to drive home. The deadliest decision in today's case was not the one with Sonny's bar serving Jessica Marks' alcohol. We know today that they didn't see her as drunk. It was Jessica Marks' plan to drive home that night. Members of the jury, today we ask that you find her bar, Sonny's bar, not liable. Thank you.
Thank you. Thank you. Any rebuttal by the plaintiff?
Yes, Your Honor. May I proceed?
You may.
Members of the jury, Ms. Rulli just told you that Stevie Rieger's testimony aligns with Ms. Marks'. That's just not true. We know that Jessica Marks was displaying those symptoms. We know she told the bar owner she was driving home, and we know that Ms. Mehta served her anyway. Don't let them blame the victim. Find them liable. Thank you.
Okay, that now concludes the evidentiary and argumentative portions of this trial. This case will be submitted to the jury for deliberation. Very well done, all of you. What we're going to do now is if everyone can just turn their cameras and their mics off, and while the jurors